Good day to you all. My name is Hilarious Wabatagore, a 3-2 student at Great Zimbabwe University. My lecturer is Mr. Nkosana Maposa, and today I will be presenting on the topic of constitutionalizing the common law in Zimbabwe with reference to the module of jurisprudence. Now, in my discussion, I will start by defining the common law, and I will define what constitutionalizing means. I'll go on to discuss about the constitutional supremacy, which is a very important doctrine in Zimbabwean law, and the theoretical affirmations for its existence. I'll also go on to show how the courts have constitutionalized common law with special reference to the Kamisho case, which is a very important case in this regard. I'll also go on to talk about the use of evolutive interpretation in developing the common law. The common law is the law applicable to all people of a given society, regardless of race, tribe, or sex. The common law is a body of unwritten laws which are based on legal precedents established by the court. The common law will influence decision-making in the courts where there is no express or written statute governing that particular case. Now, to begin with, one would have to understand where the common law stands in Zimbabwe. When you look at the hierarchy of laws in Zimbabwe, at the top of the hierarchy is constitutional law, which is the Constitution of Zimbabwe, currently the 20th Amendment. After the Constitution comes statutory law, which are the whole body of statutes that have so far been enacted in Zimbabwe. After the statutes comes common law and customary law, which have an equivalent standing in Zimbabwe. Now, the common law, as established by the Constitution of Zimbabwe, is the law that was primarily at the Cape of Good Hope in 1891 in South Africa, which was imported into Zimbabwe. Now, this law at this point was a Roman Dutch type of law, but this law had been heavily anglicized. In this regard, we mean that it had been tainted by English law. As such, it would be correct to speak of the common law of Zimbabwe as Anglo-Roman Dutch law. Now, it is important to distinguish between English law and Zimbabwean and South African law in this regard. It is correct to speak of the common law as judge-made law under English law. Only a fraction of common law is necessarily judge-made in Zimbabwe. The term judicial precedent is another one that is frequently used in this context. This is the same as judge-made law. Future courts may be bound by the interpretation that a court gives to a specific section of legislation. Although this circumstance falls within the definition of judicial precedent, it cannot be said to be judge-made law. Under Zimbabwean and South African law, the common law is mainly made up of two components, which are non-statutory law, namely a collection of terms. Judge-made law and judicial precedent are equivalent since the common law is largely predicated on judicial precedent. In the past, judges in England made legal decisions by using general notions of fairness, common sense, and morality. They gradually started adhering to the idea of stare decisis, which means to stand by the decision. The rule requiring that all judgments be built on prior decisions was justified over time as the corpus of law established on earlier decisions grew sufficiently comprehensive in its reach. The English legal system refers to this corpus of law as common law. Now, the common law relies on detailed records of analogous circumstances and laws because there is no official legal code that can apply to a case at hand. The judge presiding over a case determines which precedents apply to that particular case. The example set by a higher court is binding on a lower court. In a unique situation, there might not have been an applicable antecedent case. The courts are not permitted to rule that a dispute cannot be settled because there is no applicable law in the situation. Instead, it has to follow what can be called the guiding principle of justice and fairness in order to develop the common law. Having regard to this then now makes this topic at hand necessary because it is in the development of common law that the Constitution plays a very crucial role. Before delving into this topic, one would have to have a clear understanding of what to constitutionalize means. To constitutionalize is to make subject to the provisions of a country's constitution. It also has an interpretative meaning where it suggests an interpretation which conforms to the constitutional values. Constitutionalizing involves the attempt to subject all governmental action within a designated field to the structures, processes, and principles and values of a constitution. The Constitutional Court, in the South African case Leroux versus Day, provided for an apparent alignment between the common law of human personality and the Constitution of South Africa. In this regard, it was in the perspective of the South African transformative constitutionalism paradigm. The High Court ruling in the Lange case, which happened in Australia, avers that, of necessity, the common law must be in accord with the Constitution. Now, this has reignited interest in this connection. Australian common law cannot be developed in a way that conflicts with constitutional requirement. The Constitution mandates that common law cannot conflict with it. This is the same situation as in Zimbabwe. Now, having said this, as aforementioned, when speaking of the hierarchy of laws in Zimbabwe, the Constitution is supreme above all laws. Now, this is provided for in the Constitution, Section 2, which actually provides that the Constitution of Zimbabwe is the supreme law of the land, and that any law, practice, custom, or conduct inconsistent with it is invalid to the extent of its inconsistency. Already, this supposes that common law is inferior to constitutional law. Now, in this regard, does this mean one will have to remove the common law where it conflicts with the constitutional mandates? What it actually means is that the common law will have to be developed and be aligned to the Constitution, which henceforth will become constitutionalizing the common law. The current Constitution of Zimbabwe is a homegrown constitution whose process took close to 3 years. It was ushered through Constitution of Zimbabwe number 20, Amendment number 20, Act of 2013. The Constitution is a schedule of Section 2 to this Act. Unlike its predecessor, the new Constitution is detailed, elaborative, and exhaustive with a total of 345 sections, 18 chapters, and 6 schedules. The Constitution is the parent act of every other legislation. Therefore, all acts of parliament subordinate to it must be intra vires the Constitution or within the confines of constitutionality. Now, Gerald J. Postema argues for the congruency thesis in that the common law is intrinsically linked to the ordinary daily life and social practices. This is not sufficient for lawmakers because it offers generalizations. He cites Kant's special judgment, which is to be used and is called Matterwitz, which means common sense. But what is this common sense in a constitutional dispensation? It is the values which reflect the will of the people. However, Hobbes, in his dialogue, argues that it is not wisdom, but authority that makes law. As such, the authority is derived from the Constitution, and hence it has the right to limit the application and development of the common law. Constitutional standards are now acknowledged as basic law, and the court has asserted its right to function as final interpreters of its meaning. The contemporary constitution is now largely seen as providing the cornerstone of legal order, not only by creating the state's authoritative lawmaking institution, but also by setting the fundamental standards that drive lawmaking. As a result of this regulation, the constitutionalization of common law is required for the law to be obligatory to its people. The Constitution is increasingly seen as providing the foundation for legal legitimacy. This was seen in the case of Hamilton, where vicarious liability was developed according to the Constitution to provide justice to a citizen against the state. Now, as we defined before, the common law is the law applicable to a general people. Now, with a constitutional dispensation, this means that the Constitution is the will of the people. Hence, the common law becomes subject to change, as law is not static, but law is dynamic. And the dynamicism of this law is supposed to develop in accordance with the will of the people, which is the Constitution. According to Jules Coleman and Scott Shapiro, the law should benefit the people who are subject to it. This implies that if the law deviates from public policy, it becomes a breeding ground for human abuse. These assertions, however, are debatable. Why should the Constitution have a power-conferring aspect if it is only a document? One explanation is that it was authorized by the people. However, if this is the case, the people must be not just prior to, but also superior to the document. As a result, several social contract theorists propose two distinct contracts. The first in which the multitude forms a collective entity, and the second in which this collective entity agrees on a framework of governing, which is the Constitution. Now, having ascertained why the Constitution should remain superior and is superior, and why common law should be constitutionalized, one will then have to move on to how the courts have actually tried to constitutionalize common law. Moving on to how the courts have constitutionalized common law, this discussion will actually take delict as a primary case study, as it is mainly governed by common law. Due to the fact that delict is a legal area that is predominantly controlled by the common law, the Zimbabwean constitution requires the courts to develop the common law in accordance with it. The courts were already developing the common law on their own before there was a constitutional clause giving them the authority to do so in accordance with the Constitution. Now, this is found in section 176 of the Constitution, which actually mandates the courts to develop the common law in accordance to the Constitution. In the case of Zimland Insurance Company Limited versus Chawanda, the court ruled that the law in a developing country must be flexible and adaptable in order to adapt the law to the social and economic demands of the nation. It was said that the judiciary had a crucial role to play in shaping and developing it. In this instance, the court expanded the Aquilian action for loss of support to include circumstances in which a woman in an unregistered customary law relationship lost support as a result of her husband's passing. Every court must support and be influenced by the spirit and goals of the basic rights provision in Chapter 4 of the Constitution, according to Section 46, subsection 2 of the Constitution, while establishing new common law. Now, as aforementioned, Section 176 gives the Supreme Court, the Constitutional Court, and the High Court an inherent authority to construct common law while keeping the interest of justice and the requirements of the Constitution in mind. In South Africa, with reference to the Moses case, constitutional values can be used to fortify the arguments in favor of delictual liability. Just like the Zimbabwean Constitution, the South African Constitution states in Section 19, subsection 2, that when creating common law, every court must promote the spirit, purpose, and purpose of the Bill of Rights. Lobser and Migley point out that the South African courts have repeatedly emphasized that the South African Constitution embodies a normative value system that underpins our law and provides the backdrop against which we must develop the common law. Therefore, the Constitution expresses society's core values and sets basic criteria against which we must test laws and conduct. Right. To further show how the courts have constitutionalized common law, one will have to refer to a myriad of cases, and on the top of this list is the Camishaw case. This case illustrates the way in which constitutional provisions can help shape the law of delict. The Camishaw case heralded the birth of transformative jurisprudence. Now, in this case, the applicant implied that the common law needed to be developed beyond current precedent. X was charged with rape and murder. The investigating officer was aware of X's prior sexual crime convictions. Regardless, he persuaded the prosecutor that no cause to oppose bail, and the prosecutor agreed. After being freed on bond, X stormed into C's house, which is Camishaw, and attempted to murder her. He was found guilty of these offenses. C sought restitution from the police and the prosecution for the injury or vicarious Supreme Court of Appeal first rejected the damages claim, finding that neither the police nor the prosecution had acted unlawfully. The Supreme Court then heard the matter. In view of C's assertion that her rights to life, human dignity, equality, and security, as well as the constitutional clauses controlling police duties, had been violated, the question was whether the court should establish delict law in this regard. She specifically argued that the state ordered to women to be defended against sexual assault and violent crime. Now, when the case was brought to the Constitutional Court, it was actually confirmed that the Constitution is the supreme law and that the Bill of Rights applies to all law. It further said that under Section 39, subsection 2 of the South African Constitution, while developing common law, courts must preserve the spirit, objectives, and aim of the bill, and that when deviations are identified, they must be eradicated. The courts stated that it was implicit in Kamishal's case that the common law needs to be enlarged beyond existing precedent, as was the situation when the case was handled. The court would have to reconsider numerous considerations while considering whether or how to create a common law. The state must refrain from acting in any way that violates a person's right to life, human dignity, freedom, and personal safety, as well as its positive obligations to promote and preserve the At the end of this case, the Kamishal case, it was actually decided that Kamishal was supposed to be restituted as the prosecution and the police had failed to live up to the standards that were imposed by them by the Constitution, and it actually caused or resulted in the infringement of her rights. In such a case, the court then laid out two basic phases of investigation when confronted with constitutionalizing the common law. These two stages are inseparable. The first stage is to evaluate whether the present common law warrants development in conformity with the Section 39, subsection 2, which actually aligns with our Zimbabwean Constitution. Investigation necessitates a reassessment of common law in light of this section. If this investigation yields a good result, the second step is concerned with how such development would take place in order to satisfy the Section 39, subsection 2 goals. The preceding principles become persuasive when the question is how common law is to be formed under the Constitution. Particularly, the court is not forced to do so. Now, as the court noted in Ahmed's case, when a constitutional matter involves the direct application of the Constitution and does not involve the development of common law, cost and time consideration may make it desirable that the appeal be brought directly to this court. So therefore, this will mean that one will have to go directly to the Constitutional Court. However, the Supreme Court and the High Court have competence to establish common law as according to Section 176 of the Constitution of Zimbabwe. Now, this will have to be applied where there is no direct application of the Constitution, but there is indirect application of the Constitution. Now, in the Kamishal case, the court quoted the De Freitas case in which it said, constitutional questions are particularly important because the scope of the jurisdiction and skill in common law and its judgment are created in a fashionable way that will help advance justice. Now, there are several theoretical methods which were brought up in this case in order for one should create common law or develop common law, meeting the requirements of the Constitution. Not all of these would actually be advantageous to common law. This includes policy decisions and value judgments. These have to reflect the wishes, often unspoken perceptions of the dimly discerned and often not considered people of the society or the marginals. A balance has to be achieved within the interest of the parties and the competing interest of the communities. The attitudes of the magistrates of the other courts is irrelevant for the purpose of this case. Other cases that can be referred to are the decisions in Home Office versus Dorset Hatch Company Limited, a 1970 case, or Hill versus Chief Constable of West Yorkshire. Also, one can also refer to Barrett versus Enfield London Borough Council. Now, in contrast, the current evolution of private law in Germany is the result of German's basic law's indirect horizontal operation on private legal relationship. This so-called radiating effect of the basic law operates through the general clauses of the German Civil Code. Such clauses which are found in this clause include good morals, justification, wrongful, contra bonus mores, good faith, and so forth. Now, these clauses can be found in the values of our Constitution and are actually succinctly brought up throughout the Constitution. It would appear to suggest that when the Kamishal case was resolved, there can be an exception where the court will actually choose to absolve itself from the matter. So, it must be assumed that the facts alleged in support of the legal duty represents the pinnacle of the factual basis on which the court will be required to make the decision, since the plaintiff will be prohibited from presenting a stronger case to the trial court than the one pleaded. As a result, if such facts do not support the legal responsibility claimed, there is no reason why the exception should fail. This is significant in cases where the court is called to construct common law in accordance with this section 39(2) of the South African Constitution, which is the same as section 46 of the Zimbabwean Constitution and section 176 of the Zimbabwean Constitution, as they share intrinsic and same values. However, when the facts are complicated and the legal position is questionable, it is in the interest of justice that the judge should exercise his or her discretion to reject absolution from the instance. What this basically means is that if the law is sufficiently developed when one challenges the common law, the judge can choose to absolve from the instant. But where the facts are complicated and the legal position is questionable, in the interest of justice, the judge should actually take or practice his or her discretion in actually making a decision not to absolve from the instance, but actually go on to develop the common law. When it comes to constitutionalizing the common law, this also involves how the common law should be interpreted. Several facets of law require different types of interpretation, but with regards to this topic, which is constitutionalizing the common law, one will have to look to what is termed evolutive interpretation. This was brought about by Admag Moyo in his article Constitutional Analysis of the Interpretation Clause of the Zimbabwean Declaration of Rights. So, the human rights are inalienable to anything that happens in the discourse in Zimbabwe. Henceforth, if the common law is actually infringing on the human rights of a person, and as has been said before, if it is against the Constitution or is contravarious the Constitution, it has to fall by the side and has to be developed actually, because it is an indispensable part of the law in Zimbabwe. Dynamic or evolutive interpretation holds that where significant social and technological developments have occurred, previous legal theories outlined in court precedent should likewise evolve in the same way. The European Court of Human Rights was asked in Tyra versus United Kingdom whether physical punishment in schools was in accordance with the European Convention of Human Rights. This is as the case in Zimbabwe, where children actually received corporal punishment and the common law was developed as according to the Bill of Rights in Zimbabwe, and children, as it stands, are no longer allowed to be corporally punished. Therefore, when one is interpreting, one must have light of the current conditions. The court cannot but be influenced by developments and commonly accepted standards, right? So this means the court should be influenced by the commonly accepted standards, and in this case, it is the Constitution, which is a product of the will of the people. In K versus Minister of Safety and Security, a South African case, the applicant, who was brutally raped by 3 uniformed policemen who had given a lift, sought leave to appeal against a Supreme Court of Appeal decision holding that the respondent was not vicariously liable for the policeman's conduct because when the standard test for vicarious liability of whether there had been deviation from the course of employment was applied. The policeman had deviated. One of the grounds of appeal was that the common law test for vicarious responsibility had been used incorrectly by the Supreme Court of Appeal, and that if it hadn't, the test needed to be established in accordance with Section 39, subsection 2 of the South African Constitution. Reference has been made mostly to South African cases because Zimbabwean jurisdiction lacks in this regard, and as such, from a paper which was developed by Professor G. Felto, he actually urges the Zimbabwean courts to follow the South African example. Now, in this case of K, the courts determined that the main goal of Section 39.2 of the South African Constitution, which is similar to our constitution in Zimbabwe, was to guarantee that constitutional principles were incorporated into common law. This normative effect had to apply to all of common law, not only situations where the current laws were blatantly against the Constitution. So this suggests that there does not have to be a situation where the common law is not directly in conflict with the Constitution for it to be developed. But if there is, however, even slight a misunderstanding between these two laws, the common law has to be developed to fall exactly as the Constitution prescribes. Now, this demanded that the courts should be mindful of the Constitution's normative foundation in all instances, not just those involving a startlingly novel common law development. It was determined that the safeguarding of the applicant's fundamental rights to personal safety, dignity, privacy, and substantive equality was extremely important from a constitutional standpoint. The public's protection and security, as well as crime prevention, were among the responsibilities of every police officer. The Police Act provisions recognized them as constitutional duties. The court ruled that the concepts of vicarious responsibility and their application needed to be refined in order to be better aligned with the spirit, purpose, and purposes of the Constitution. This meant that the existing rules of common law vicarious liability had to be interpreted and used within the normative framework of the Constitution and the social and economic goals that they aspired to achieve. The ministry was held vicariously liable for the improper conduct of the police officers. Evolutive interpretation becomes an effective instrument for the realization of human rights when the Constitution or law is being interpreted. This is because the conditions in which the Constitution in question was originally intended to rule frequently changes over time, necessitating the court's flexibility in accommodating emerging ideals and societal aims. Referring back to how the common law was defined before, which includes judge-made law, stare decisis, which is abiding by previous decisions, which means the court can actually go against previous decision if there is reason to believe that upholding such decision would result in infringement of constitutional rights. Now, in the Van Eden case, a 19-year-old woman was sexually assaulted, raped, and robbed by M. M had escaped from police custody around 2.5 months earlier through an unlocked security gate. She sued the state before the provincial division, requesting punitive damages, claiming that the police ordered to her to stop M, a dangerous offender and serial rapist, from injuring her, and they had negligently failed in that duty. The court rejected the appellant's claim on the basis that under Camichel versus Minister of Safety and Security, the police had no legal responsibility to act affirmatively to avert injury. As this court case developed, the Supreme Court of Appeal, however, emphasized that the police have a legal obligation to act constructively to safeguard people by actively preventing violations of the fundamental right to freedom and security of person, which included shielding everyone from violent crime. By carelessly permitting a non-violent criminal to escape police custody, the police had failed in their duties. The test now was whether an omission must now include constitutional norms, values, and principles, and must depend upon the community's legal conviction. This was the case, and for legal purposes, the Constitution a system of objective normative norms which actually entails the right to dignity and other freedoms was used to develop this common law. Several cases, which include the Van Dueverbodden case, which is also a South African case and concerns vicarious liability, falls within the ambit of what has just previously been discussed. Now, in conclusion, one then sees that it is very important that the common law be constitutionalized in Zimbabwe. This process, however, is provided for in the Constitution and it is guided by the Bill of Rights. Section 176 of the Zimbabwean Constitution and Section 46.2 provide clearly how the courts should actually develop the common law. Reference can also be made to the Barkhuizen case, which is a South African case in which the doctrine of Pacta Sunt Servanda was actually discussed. Now, the courts did not seek to actually remove the statutory law at the time. Now, even though this case is not about mainly the common law, regard should be had to what the court said in this case, which is that the courts actually should develop and rather not remove. Hence, the common law, for it to remain valid and viable as a source of law in Zimbabwe, should indeed be constitutionalized, which is actually bringing it up to date, as can be noticed that the Constitution of Zimbabwe was actually done after several referendums and is more modern and actually embodies the will of the people, whereas the common law dates back to the Cape of Good Hope, a situation whereby, as previously discussed, this generation should not be bound by situations which existed in a previous generation, which are not in alignment with what actually the people are facing and would result in subsistent injustice. And henceforth, the common law should actually be constitutionalized as provided for before. It is under the Constitution and it is necessary in the interest of justice and fairness. Thank you.